Legal descriptions. If I say 123 Main Street, do you think there's more than one Main Street in North Carolina? If I say 123 Martin Luther King Jr. Boulevard, do you think there's more than one Martin Luther King Boulevard in North Carolina in general? There's about 72,000 Martin Luther King Jr. boulevards in just like 3 states, right? Let alone the entire country. I think there's like a million Martin Luther. He's a very prominent figure. If I said, I'm going to sell 123 Main Street to you for $200,000, and you look up 123 Main Street, and you're like, God, that is a beautiful mansion. And we go through the process and you buy the house and I hand you the keys. And I say, congratulations, Cam, you own 123 Main Street. And you show up at that mansion and your keys, you're jiggling them and they're not working. And you walk off the porch and you call me and you're like, Seth, the keys aren't working. Well, Cam, where you at? I'm standing at the house waiting for you. I'm like, oh my God, Cam, are you at that mansion? No, Mike, you're such a silly goose. No, Cam, you just bought 123 Main Street, this dirty, dilapidated mobile home I had on 10 acres over here on the other side of town. Come on, man, this family of rabid possums is looking me over and making me uncomfortable. Get on over here and open this door so you can take your house. Would you be upset, Cam, if you thought you were buying a mansion and what you got was a molehill? So legal descriptions are important, so there's no question about what property you're getting. That is what the word legal description means. It is any type of description that would be legally adequate for a surveyor to discover which property we're talking about. So that way it doesn't just leave it up to ambiguity. 123 Main Street's not enough. So we would give you different types of legal descriptions. Remember, we have 4 that we talked about. Meets and bounds legal description, part of the original 13 colonies, came over from English common law and everything. We still use that today in North Carolina because we were one of the original colonies. Then we've got reference to recorded plat, which goes back to those developers. That is more common in urban areas where they basically have a civil engineer draft up a map, have a surveyor stake it all out, and then they will record the map in the county in which the properties are located in. And now we reference lot 2 of phase 1 of Willow Hill subdivision. Then we also have the government survey system, also called the rectangular survey system, that is west of the Mississippi River. And that is the one that uses townships and sections. You do need to know that a section contains 640 acres and that there are 36 sections in one township and how the legal descriptions go. And then the last one is reference to a recorded deed. And the reason being, recorded deeds, they have to contain a legal description on them. That was part of the essential elements of a deed. So if we reference the deed contains another legal description like a meets and bounds. So all of those are different types of legal descriptions that would be considered legally adequate to transfer real property. But when we're dealing with deeds or any filings for that matter, we are in what's called a pure race state in North Carolina. First come, first serve. Deeds, when you record them, you are giving constructive notice to the public that you are the owner of record. If you don't, then you're not really protecting your interests, which is why we record it. When we get into other things, and I just want to make sure you understand this first come, first serve. Let's say liens, right? Liens are also recorded against property, specific liens, right? Or recorded against a piece of real property. And they are paid out in like a first come, first serve basis. So when we have a mortgage recorded, it would be a senior mortgage, and then any secondary would be a, secondary mortgage or junior mortgage, and we would pay them out in order of recordation. Well, remember when we had certain things, certain liens like real property tax liens and special assessments, they set it a higher priority, meaning that even though they may be recorded later, they're more important and they get paid out first. So when you get test questions in regard to paying out the order, it's going to be first come, first serve, unless there's real property taxes. Those are always first. Special assessments beat out everything except for real property taxes. Foreclosure is the banks forcing the sale. It's not the banks taking your property. That's a misconception. It is forcing the sale of your property to satisfy the debt that you owe them, that you pledged your house as collateral for. If we're dealing with a foreclosure costs are always paid first, but they're not technically a lien. But we can't have a foreclosure unless we pay the foreclosure cost. So if you get a test question that talks about, what's getting paid first in a foreclosure, it's always going to be foreclosure costs first, then real property tax liens, then special assessments liens, then everything else is going to be in order of recordation. Whichever was recorded first will be paid out first. The only other exception to that is mechanics liens. Remember, mechanics liens kind of this special rule that when they're recorded, they basically sit as if they were recorded on the day that the work started or materials were dropped off, even if they're recorded 9 months after that. Now, you only have a set period of time to record them and a set period of time to foreclose as the contractor, but they do have that special order of priority. So when we give somebody a general warranty deed, think of it like if you've ever go to Best Buy or Target or Walmart and you buy an electronic device, what do they always ask you if you want? The extended warranty. Because every time you buy something, it's kind of got a manufacturer's warranty, but it's typically like 1 year. If it's going to crap out, it's going to crap out at like 1 year and 1 month, right? And you're like, dang it. So they ask you if you want this extended warranty that basically covers anything and everything. If you drop it, we'll replace it. If you lose it, we'll replace it. If you do this, we'll replace it. General warranty deeds should be thought of like your extended warranty. When somebody gives you this general warranty deed, they're giving you all these crazy things, right? These kind of funny words, but don't let these things scare you. We say the covenant of season. Well, the covenant of season just says they had the right to convey it to you, and you now have the right to convey it to somebody else. That's all it means. When you get it, you can then give it to somebody else. Covenant against encumbrances. Encumbrances is kind of a very broad term. Remember, what did we think when we say the word encumbrance? What do we mean? What should you be thinking of with this word encumbrance? Any limitation. If it limits the property in any way, shape, or form, it's called an encumbrance. We can have physical encumbrances. We can have financial encumbrances. And then the other thing too, remember, encumbrances aren't inherently bad. Restrictive covenants are a type of encumbrance. Some people love having restrictive covenants, so it keeps their properties looking good. Some people hate them. So an encumbrance is just a limitation. So when we say covenant against encumbrances, well, we can't promise you don't have restrictive covenants. So what we mean is covenant against encumbrances, except for those disclosed to you. Obviously, easements and restrictive covenants and certain things we can't get rid of, but you know about them. So we're saying there's no financial encumbrances or otherwise that are hidden. Covenant of quiet enjoyment. This one's kind of funny. When we say quiet enjoyment, it does not mean that you're just sitting there on your property like, yeah, this is nice. It's super quiet. I'm really enjoying this. That's not what it means. It means nobody has the ability to claim superior title. Nobody else can claim that they own it more than you do. That's what quiet enjoyment means. Covenant of further insurance and covenant of warranty forever says no matter how long you own it, you're not going to have any issues. And then warranty forever. If you do have issues, I will come back and fix them. So this is like your bumper to bumper warranty, right? Your full extended warranty. If there's an issue, we'll fix it. So this is the best type of deed to get as a grantee, and it gives the most liability to the grantor. It says, you're going to have to come fix this. Like you're promising some pretty serious things here. Also sometimes just called a warranty deed. When we're dealing with general warranty deeds, right? Highest, best, bumper to bumper warranty protections. Then we go a step down, okay? And that is your special or limited warranty deed. These not exceptionally uncommon, believe it or not. There's a lot of different ways that you can convey ownership with different deeds. So this one has limited warranties. Think of this as like the manufacturer's warranty. We're warranting some stuff, but not everything. It warrants that the grantor receive title. In other words, I do own it. I've received title. I'm telling you that, right? I'm promising you that. And it warrants that the property was not encumbered by the grantor during his ownership. So what we're saying is, I do own it, and I've not done anything to mess up the titled ownership and the time that I've owned it. We're not talking about anybody else though, right? If I've owned it for 5 years, I'm saying I promise in the 5 years that I had it, nothing's happened. I don't know about the 25, 30, 40 years before that. So it is a limited warranty. I warrant that I received good title, and I warrant that I did not do anything to encumber it. And now this is usually associated with a foreclosure. When we're dealing with a foreclosure, I told you that's when the banks force the sale and it goes to auction. Sometimes the banks will auction the property and make a bid on it themselves. Why? To make sure that they get a certain amount of money. If they bid on the property themselves and they don't end up getting beat, sometimes the banks end up owning the property. And that is what we call REO or bank-owned property, right? Real estate owned or bank-owned. If the bank was to own the property, then they would go through a typical sale, list the home, and you would purchase it as a bank-owned property. Well, what they're going to give you is a limited warranty deed. Because let's say that they got it at auction and they held it for a year and then finally sold it. They're going to say, yeah, we got title by way of this foreclosure legally. We didn't do anything to encumber it for the time that we had it. That is very common with that type of transference, because they're just saying we didn't do anything, but we're not promising that the previous owner didn't do anything. Special warranty, also called a limited warranty. You do not have to give what you got. So if you purchased it at auction and the banks gave you a limited warranty deed, could you then turn around and sell it and then convey a general warranty deed to somebody? Absolutely. All it is just providing a warranty. You're not doing anything special to the title. You're not doing anything special to the property. It's just the amount of liability that you want to give yourself. And if you feel comfortable that there's no issues, give a general warranty deed. You could get a general warranty deed and you could give a special warranty deed. You can switch it. Doesn't matter. There's no rule stating that you can. Bargain and sale deed is almost the lowest rung of the totem pole. There are no warranties involved in a bargain and sale deed. It doesn't warrant that there's no issues. It doesn't say anything about anything. What it does do, this would be an example of an attorney showing up your house knocking on your door and saying, hey, I just wanted to let you know that your great uncle Steve passed away and he left you his house in Wisconsin. And you're like, I didn't even know I had a great uncle Steve. So you never met him. You didn't know about him, but apparently through some law of intestate succession, you inherited a property. Well, you don't have any desire to go to this house or to Wisconsin. So you call up an attorney and you say, find me an agent, sell this property. And it is what it is. So you may give somebody a bargain and sale deed at this point because you're like, I was told I own it. Apparently, I had a great uncle Steve. I'm going to sell it to you now because you don't know for a fact. You didn't know anything about it. You're not sure that you own it. Does that make sense? It's like, well, I guess I own this and I'm giving it to you. You're not warranting that there's no encumbrances. You're not promising that there's nobody out there claiming superior title, but you are saying, I think I own it and I'm going to give it to you. Now, here's the big differentiation. It says very similar to a quitclaim deed. Let me explain the difference. In a quitclaim deed, you're not even saying you own it. Quitclaim deeds are more commonly associated with divorce and title defects, right? When somebody may have a claim to a property, but we're not sure. So when you sign a quitclaim deed, you're saying, I don't know if I have an ownership interest or not, but if I do, I'm quitting my claim to it. It's yours. So this is very common with divorce, right? If you own a property and then you get married, well, your spouse has a marital interest. Let's say you were married for 3 months and then you get divorced. They still technically have a marital interest. How much? Who knows? So you would find this person and ask them to sign a quitclaim deed. So that way you can convey clear title. We don't know if they have an ownership interest. And if they do, we don't know how much. So they're saying, I don't know if I own it or not. I don't know if I have a claim to it or not. But if I do, I am, like the name implies, quitting my claim to it.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.